Yes, Mr. Man, are you in this matter, please?
Yes, sir.
As what? As who?
One of the clients, sir.
From where? From where are you joining? From Okodi?
Yes, sir.
What's your name?
Ogidi Ronald Ogo.
Eh?
Ogidi Ronald Ogo.
Ogidi
Ronald Ogo.
You are among the 118 claimants?
Yes, sir.
Okay. Ogidi Ronald, I'm trying to trace.
Ogidi, O-G-I-D-I. Ronald Ogo.
Okay. Okay. That's claimant number 26.
Yes, sir.
26 claimant is present.
Yes, sir.
26 claimants present. Other parties absent. So this is my judgment.
As a God,
Mr. Ronald, you can now mute yourself so that it will not be disturbing us. Mr. Ehan, the claimants commenced this suit by a complaint and other accompanying processes dated 15th September 2017, but filed on the 18th October 2017 and asked for the following reliefs against the defendants as contained in paragraph 17 of the assessment of facts. Number one, an order declaring that the omission and or removal from the payment voucher and the non-payment of the claimant's salaries for over 28 months is malicious, null and void. Number two, an order compelling the defendant to re-include the claimant's name in the payment voucher of Oju Local Government Council. Number three, an order compelling the defendant to pay the claimant their arrears of salaries for over 28 months now until the termination of this case and to pay the subsequent salaries as tabulated in the assessment of claim below. Number five, a perpetual injunction restraining the defendants, their agent, previous servant, or howsoever called from interfering with the names of the claimant in the payment voucher or payment of the claimant's salaries. Number six, general damages of 100 million naira only for the physical and psychological trauma and inconveniences suffered by the claimant as a result of the defendant's action. Number seven, cost of prosecuting this action assessed at 1 million naira only. Number eight, 10% interest on judgment sum until the same is duly liquidated. The first and third defendant upon service of the claimant's originating processes responding to the claimant's case by filing their joint statement of defense on April 9, 2018 via leave of court, asking the court to dismiss the claimant's suit for lacking in merit. The claimants by leave of court also filed a reply to the defense of the first and third defendant on 17th of June 2019 that even though the second defendant was served with all court processes, but there was no appearance or defense filed on their behalf. Case of the claimant. The facts of the claimant's case is that they are employed by the defendant between 2008 and 2011. Between 2008 and 2011, I received confirmation letters that they worked diligently, received promotions, and were paid salaries until July 2015, when the defendants suddenly stopped paying their salaries by removing their names from the local government payment voucher without a valid reason. Claimants are now suing to have their names reinstated on the payment list and receive payment of their outstanding salaries. Case of the first and third defendants. The defense of the first and third defendant is that the appointment of the claimant was found to be irregular, illegal, and a nullity. Hence, the stoppage of their salaries. According to the defendant, the claimants were smuggled into the service of the defendants through dubious means. As the laid-down procedures were not followed. The claimants are not physical persons, but exist only on paper for the benefit of some corrupt officials in the public service. The defendant contended that the claims of the claimants be dismissed as lacking in merit. Upon close of pleadings, trial commenced on 17th October 2019 with the ninth claimant, Ogriokpo Samuel, who testified as CW1 by adopting his deposition dated 26 March 2019 and tendered the following documents as exhibits. 118 appointment letters, exhibits OJU1A, 118 confirmation letters, exhibit OGUB 1 to 118, promotion letters, exhibit OJUC, biometric data printout, exhibit OJUD, bank statement of account, exhibit OJUE, list of cumulative salary, exhibit OJUF, 3 demand letters, exhibit OJUG, and 58 identity cards of some of the claimants, exhibit OJUH. The CW1 was cross-examined by the defendant, and in absence of re-examination, the CW1 was discharged and the case of the claimants was closed. On the 12th of November 2020, one Tobunde S. Sate testified as DW1 on behalf of the defendants. He adopted his statement on oath made on the 9th of April 2018, but tendered no exhibit. DW1 was cross-examined by the claimant's counsel, and there was no cross-examination. He was discharged, and the case of the first and third defendant was closed. The case was not adjourned for adoption of final written addresses. However, none of the defendants has filed any written address. Submissions of the claimant. Final written address of the claimant dated 9th February 2021 and filed on the 17th February 2021 contains 2 issues for determination as follows. Number 1, whether the claimant's employment is regular and proper. Number 2, whether the removal of the claimant's names from the payment vouchers and non-payment of their salaries is lawful. This is a submission of learned counsel for the claimant that the first issue be answered in the positive. That the claimant's employment is regular and proper, and also one with statutory flavor. Relying on the cases of New Nigerian newspaper and Mr. Felix A. Toebi, NEPA and Adesaji, and section 2 rules 02203, 02205, and 02207 of the Benue State Public Service Rules. Council reiterated that an appointment with statutory flavor is that appointment and termination that is protected by statute or laid down procedures. That the claimants were employed as junior staff from grade levels 1 to 5 by the defendant and rose through the ranks. It is also submission of counsel that the defendants never challenged the procedure for the appointment of the claimants all through their defense. That the claimants stated in their evidence and exhibits OJUB, OJUC, D, H, and E that they were duly employed by the first and second defendants. They underwent the probationary period. Their appointment was confirmed. They enjoyed promotions. They are issued with staff identity cards. and they underwent verification exercises conducted by the defendant and issued biometric data printouts. That all these exercises and procedures for the appointment of the claimants are evidenced by the documents tendered as exhibit before this court. It was argued that this established a presumption of regularity in the employment of the claimants. It was also argued that these exercises that have not been challenged by the defendant constitute uncontroverted evidence which the court have established as admission. In support of this principle, counsel cited the case of Okiki and LPDC. Counsel submitted further that where there is an intentional representation that has been acted upon by the other party, the first party is precluded from denying the existence of state of affairs. Counsel cited the case of Bank of the North Limited and Baturi and Section 169 of the Evidence Act. Counsel contended that the defendants who alleged under cross-examination that the staff identity cards issued to the claimants were forged never produced the original before the court to contradict the ones already before the court. That the law is clear that he who asserts must prove, citing the case of Buhari and Obasanjo. Counsel also contended that the defendants are stopped from declaring the claimants as ghost workers in the guise that their employments were irregular and improper when the same defendants diligently subjected the claimants to step-by-step employment processes and issued the various documents admitted as exhibits. Counsel relied on the case of Ann, Menakaya, and Menakaya. In conclusion of this issue, counsel posited that even if the employment of the claimants was irregular, the defendants ratified and validated the same by allowing the defendants to draw salaries for 5 years and receive promotion. Hence, they cannot turn around to declare them ghost workers. The court is therefore urged by counsel to resolve this issue in favor of the claimants. Issue 2. Another counsel answered this issue in the negative and submitted that the removal of the claimants' names from the local government payment voucher and stoppage of their salaries is a procedure unknown to law, hence unlawful. Counsel also submitted that unemployment is a thrift labor can only be terminated according to the procedure in the statute. Counsel relied on the case of Dr. Bamboy and Yuni Ilori and Oedele and Ife UTC. In his forward submission, counsel stated that the removal of the names of the claimants from the payment voucher and the stoppage of their salaries amounts to dismissal or wrongful termination. Thus, they're entitled to be reinstated and relisted on the payment vouchers as usually done in contrast of employment with a thrift labor. Counsel cited the case of Olaniwaju and Afribank Nigerian PLC. Counsel contended that for wrongful dismissal or termination, the claimants are entitled to award of general damages, and cited the case of Savannah Bank Limited and Pakokum. Counsel finally urged the court to resolve issue 2 in favor of the claimants and grant all their claims that they have been able to prove their case on preponderance of evidence. Court's opinion. Having carefully studied the pleadings of the parties, the evidence adduced, and the submission of the claimant's counsel, to me, the pertinent question to determine, the pertinent issue to determine is whether the claimants have established their claims on preponderance of evidence to be entitled to the relief sought. As it was shown earlier, the grievance of the claimants before the court is that they are employed at various times by the first and second defendants between 2008, 2010, and 2011, and following letters of temporary appointment, that their appointments were confirmed, they enjoyed promotions and were verified sometimes in 2014, and issued biometric printouts, that they are also receiving salaries until 2015 when their salaries were stopped by the defendants and their names removed from the payment voucher of the first and second defendants. It is the law that in civil claims, he who asserts bears the burden of proving that which he asserts. And the burden of proving the existence or non-existence of the fact lies on the party who would fail if no evidence is adduced in his favor. See sections 111, 131, 132, and 133 of the Evidence Act. See also the case of Lawrence and Odumi. The claimants in founding their case have placed reliance on numerous exhibits to establish their claims. They have tendered exhibit OJU-A1, OJU-B1. The claimants in founding their case have placed reliance on numerous exhibits to establish their claims. They have tendered exhibit OJU-A1 to 118 appointment letters, OJU-B1 to 118 confirmation letters, OJU-C1 to 118 promotion letters, and exhibit OJU-D1 to 118 biometric printouts to establish their respective appointments by the defendant, confirmation of same, and the promotion and verification of the said appointments. I need to mention and observe that the second defendant who was served with the process of this court and numerous hearing notices never appeared nor filed any defense to join issues with the claimants all through the trial. In the case of Esoho and Asuko, it was held thus, and I quote, it is the responsibility of the defendant to join issues with those aspects of the plaintiff's pleadings he disputes, or consider that the plaintiff ought to establish. Where the defendant declined to do so and does not join issues on such issues, and on such matters, the facts so pleaded will be deemed to have been admitted, unquote. Also, in the case of Mali and Abubakar, it was held that while the defendant fails to file a defense, judgment may be entered against the defendant in favor of the claimant on the basis of the alignment in the system of claim as such is deemed not denied. Thus, while the defendant fails to adduce evidence in denial of the alignment in the claimant's claim, such a defendant becomes vulnerable to relief sought. See also the case of Ume and Ibe. Therefore, where evidence is given by a party and is not contradicted by the other party who has the opportunity to do so, and such evidence is not inherently incredible and does not offend any rational conclusion or set of physical things, the court should accord credibility to such evidence. In the case of Ghana and FRN. Furthermore, in the case of Usman and Abubakar, it was held that where evidence is uncontroverted and unchallenged, the court is at liberty to act on same. In their first relief, the claimants are seeking for an order of the court to declare the removal of their names from the payment voucher of the defendants and the non-payment of their salaries as malicious, null and void. It can be observed that the numerous exhibits presented by the claimants demonstrate their employment status of the defendant. Exhibits OJU A1 show that the claimants were duly employed by the first and second defendant, and exhibit OJU B1 to 118 indicate that they are confirmed, while exhibit OJU C1 to C118 disclose that they are promoted. And again, exhibit OJU D1 to D118 showed that the claimants underwent screening exercise and biometric data printouts were issued to them. According to the claimants, they are properly employed and underwent all processes. Hence, their employment was proper, and they are not ghost workers. They have also been receiving salaries from the defendant for over 5 years. But the defendant, on the other hand, have denied the appointment of the claimants and have contended that the appointments were done without compliance with the proper procedure. Thus, the letters of appointment issued were fake. First and second defendant who bear the burden to establish the above contention not lead evidence in proof thereof. It appears there is no evidence from the side of the defendants that the claimant's appointment letters were fake. I observe that the exhibit tendered by the claimant without any objection from the defendant clearly shows that an employment relationship existed between the claimants and the defendant, which on the face of each exhibit shows regularity of an employment process. All the exhibits were signed by the officers of the defendant and were on the letterhead of the first and second defendants. The biometric data biometric data capturing and verification exercise carried out by the defendant and tendered as exhibits OJU D1 to D118 were never refuted or shown to be fake. I observed also that each biometric printout gave the status of each of the claimants as confirmed. And I wonder how the claimant's appointment became irregular or fake. The first and second defendant have contended that the defendants never employed the claimants and are not responsible for the payment of their salaries, and that the second defendants have no approval to employ the claimants because it ultraviolates its powers, that the employment did not follow the laid down procedures, and that the claimants were not legally employed in the service of the defendants. Nevertheless, the above contention appears to be contrary to the exhibits presented by the claimants. They were duly employed, confirmed, promoted, and biometrically captured by the defendants. I note the evidence of DW under cross-examination to the effect that the first and third claimants were promoted by the first defendant. DW went further to state that from the exhibit presented by the claimants, all the other claimants were promoted by the first defendant, but through dubious means, irregular activities, and without due process. Exhibit OJUC1 to OJUC118, which are promotion letters of the claimants from various grade levels, emanated from the office of the first and second defendant. And some of the exhibits were signed by the Director Admin and Finance, POOCO, for the Chairman Local Government Service Commission, and others signed by some other officers of the defendant. Similarly, the evidence and exhibit before this court revealed that the claimants were employed between the period of 2008, 2010, and 2011, and placed on different grade levels. It is also evident that the claimants were receiving salaries and were posted to various departments of the second defendant before the abrupt separation of their salaries in July 2015 upon removal of their names from the payment vouchers. It shall be presumed and of course underscored that the above acts of the first and second defendant seem to show that the employment of the claimant was regular. See the provisions of section 1681 and 169 of the Evidence Act, which is stated as follows. When any judicial or official act is shown to have been done in a manner substantially irregular, it is presumed that formal requisites for its validity were complied with. Section 169 says, and I quote, when one person has either by virtue of an existing court judgment, deed or agreement, or by his declaration, act or omission, intentionally caused or permitted another person to believe a thing to be true and to act upon such belief, neither he nor his representative shall be allowed in any proceedings between himself and such person, or such person's representative in interest to deny the truth of that thing on court. I need to note that the defendant's attitude of confirmation of the claimant's appointment, promoting the claimants, capturing them, and payment of their salaries for 5 years would definitely put the claimants in a position to believe that they were duly employed by the defendant, and I so find. Claimants have asked for an order of the court to re-include their names on the payment voucher of the second defendant, and to direct the defendant to pay their arrears of salaries for over 28 months or to the claimants until the termination of the case. Claimants have in their evidence through CW rightly maintained that the respective appointments with the defendants are valid and subsisting, as none of their appointments has been terminated or dismissed. The defendants, especially the second defendant, as was earlier stated, did not file any defense to deny the employment of the claimants, their confirmation, verification, and payment of their salaries, even though the first and third defendant contended that the first defendant did not have his approval to employ the claimants, thereby making the employment of the claimants irregular. However, from the set of the pleadings in this case, the testimonies of witnesses and the avalanche of documents presented, it's clear that the evidence of the claimants as regards their employment remains unchallenged and undisturbed. It is the law that where an employment relationship has been created in writing and accepted by the parties, then it creates a sanctity of contract with the court must respect and give effect to at all times. See the case of AG Rivers State and AG Akwa Ibom, while Supreme Court held thus, and I quote, where parties have entered into a contract or agreement voluntarily, and there is nothing to show that same was obtained by fraud, mistake, deception, or misrepresentation, they are bound by the provision or terms of the contract or agreement, unquote. It is therefore the right of the claimants to be paid their salaries monthly for the period of work done, and such right cannot just be taken away for no just cause or for a supposed lapse on the part of their employers. In the case of Ode Bunam and Federal Capital Development Authority, the Supreme Court held that a worker is entitled to wages that are earned, and this right is automatically implied into a contract of employment. Exhibit OJU A1 to A118 represent the contract of employment between the claimants and the defendant with the agreement to pay salaries as reflected on each letter. The position of the law as regards the payment of salaries and wages has remained unchanged. That is, the right to receive salary or wages is determined by the letter of appointment as said in the case of Jeremiah and Zregby. It is therefore the duty of an employer to pay wages or salary in accordance with the terms of the contract, whether expressly stated or implied to the employee. In the case of Browning and Value Colors Limited, Greer J said that an employer is under a duty to pay wages or salary to his employee, while the terms of the contract say so. See also the case of Way and Latila. I must underscore the point that when evidence is uncontroverted or unchallenged, the court can act on same. See the case of Usman and Abubakar. Claims have therefore made out a case for the grant of the relief sought, and I make the following declaration and orders. Number one, a declaration that the omission and or removal of the claimants from the payment voucher of the dependents and the non-payment of the claimant's salaries for over 28 months is malicious, null and void. Number two, an order directing the defendant to include the names of the claimants on the payment voucher of the second defendant, Uju Local Government Council. Number three, an order directing the defendant to pay the claimant their arrears of salaries from June 2015, when their names were removed from the payment vouchers to date of judgment, and subsequently until the termination of their employment. Number four, an order of perpetual injunction. An order of perpetual injunction restrain the defendant from interfering with the names of the claimants in the payment voucher of the second defendant or payment of the claimant's salaries until the termination of their employment. The judgment shall attract 10%. The judgment sum shall be paid within 30 days from today, failure of which it shall attract 10% for judgment interest per annum until it is fully liquidated.
My Lord, we are very grateful for this well-considered judgment. This has reinforced the fact that judiciary is the last hope of a common man. My Lord, this matter has cost me a lot of backlashes, a lot of blackmail. In fact, they say that I have sold the matter, that the governor has given me money. Yes.
Okay.
So all the claimants,
how can you sell the matter?
made my name across the country. But we thank God that God has placed you to enforce judgment and justice. I pray that God will prolong your life and grant you good health. Thank you, my Lord.
Thank you so much, Mr. Omenka. Thank you so much.
Thank you. Thank you.
Thank you.
My Lord, we'll be magnanimous in our victory. We will not ask for cost.
Okay. Thank you.
Yes. Thank you, sir.
Okay, Mr. Omenka.
Yes, my Lord.
In absence of any other thing, that will be all for today.
Yes, sir.
My regards to everybody over there.
Thank you, my Lord.
I thank you so much.
We
And I
are-
wishing
we are most-
you
Thank
good
you, sir.
afternoon. And
Thank you, sir.
happy weekend in advance.
Thank you very much, my Lord.
Thank you.
God bless you. Thank you.
So, oh my God, it can only be God. It can only be God.